हाजरीन इकराम, सुबह बखैर। मौजू वर्चुअल लेक्चर सीरीज पे मुनाकिद आज के पुरखुलूस मौके पे हम नवजीवन लॉ कॉलेज के सरबराह डॉक्टर शाइस्ता इनामदार, तमाम उसातिज़ा इकराम, मेहमान खुसूसी डॉक्टर पंकज उम्बरकर, सिम्बोयसिस लॉ स्कूल हैदराबाद और इस बज़्म में मौजूद तमाम समाइन का इस शेर के साथ तहे दिल से इस्तकबाल करते हैं। गुलों में रंग भरे बादे नौ बहार चले, गुलों में रंग भरे बादे नौ बहार चले, चले भी आओ कि गुलशन का कारोबार चले। I hereby welcome all the dignitaries for the Day 9 Phase 4 Intellectual Property Rights. I request Principal Dr. Kundendu Kumar Dev sir for his welcome address.
Thank you, Saista. On behalf of the Navjeevan Education Society's Navjeevan Law College, as our coordinator Dr. Saista has said that we are conducting the virtual lecture since December 29th onwards, and this is the fourth phase which are on way. Today, our resource person, Dr. Pankaj Umbarkar, has accepted our invitation to deliver his lecture on the topic which is said to be the spectrum and trademark and geographical indication and its distinctiveness. I hope this is a very vast subject and it will give you a very sound knowledge with regarding the IPR and specifically the trademarks and the geographical regions. Sir, on this occasion, I welcome you from the bottom of my heart and hope that you will enlighten the students and the participants along with your experience. I also welcome all the participants, my beloved students, who are in more numbers for this virtual class. I am very much glad and happy that the students are taking participation in each and every virtual class and the response is very nice. I welcome them. I also welcome the dignitaries and the personalities who are also a part of this virtual class, which gives more impetus to this virtual class. And what would be the standard of this virtual class and how keen they are to listen to these subjects which we have opted. Last but not least, to my faculty members and each and every person who has contributed a drop of water to this virtual class. Thank you very much. Back to Sahista.
Thank you, sir. And I would like to say, as sir is from Hyderabad, that is why we have given a cultural welcome to you, sir. Now, as towards the subject, subject is your trademark. As dear participants, you all know that even in rural places, if generally we travel a lot, so we see whenever there is a shop, and if you go there and you purchase, for example, I would like to say Parle-G. Everybody has seen Parle-G biscuits. So if you see that, so in the rural areas, the name has been changed to Parla-G, and the similar face of that child is there. Similar packing is been there, but the products are the deceptive products. So basically, we can see this in large places in rural areas, times where the people are illiterate. They doesn't understand the spelling. So basically, they just see the outerior view. Like for example, coconut oil. Even if we go, we just see blue color bottle. That is sufficient for them. Vicks, if you see green and blue color combination, but the spelling of VICKS and VIS is different. This many a times it happens with us also that maybe due to our busier schedule it is not possible for us to read it. But later on when we go home and then we see, then we find some deceptive goods are also there. That is why Navjeevan Law College has chosen this topic for the virtual lecture series. Now, I request co-coordinator of this virtual lecture series, our senior most faculty, Pandey sir, for introducing the guest. Over to you, Pandey sir.
Yes, thank you, ma'am. Very good morning to all of you. Principal Dr. Dev sir, today's resource person Pankaj Umbarkar sir, coordinator Dr. Chaista Inamdar madam, other faculty members and my dear students. Today, in the fourth phase, we have chosen the topic, the spectrum of trademarks and geographical indications and its distinctiveness. And the resource person for this session is Dr. Pankaj Umbarkar. He is presently working as an assistant professor, Symbiosis Law School, Hyderabad. He has completed his LLB and LLM from Sant Gadge Baba Amravati University and completed his PhD from Rashtrasanta Tukaramji Maharaj University, Nagpur. He taught number of subjects at Max Law School and Max University, Raipur, including CRPC, CPC, evidence, family law, international law, and the various practical training subjects, including the drafting, pleading, and conveyancing. As a former legal practitioner, Professor Pankaj brings his experience into classroom and law school community. He used to teach the students in more dynamic way and skills. He has been honored by the Moot Court Association Symbiosis Law School, Hyderabad, for his efforts to help the students law school in research and argument development. He worked as a board of studies member in various universities. He has been member of Commonwealth Lawyers Association. He worked as a member of secretary on the committee for SOP, Symbiosis Law School, Hyderabad, for the LLB and LLM curriculum, for contributing educational innovation, research, designing, etc. He has been invited as a chairperson in various conferences and seminars and published about 30 research papers in various national and international conferences and seminars. So I welcome Dr. Pankaj Umbarkar, sir, and request him to address our students. Over to you, sir.
Okay, thank you so much, sir. Thank you for kind of words you have taken. Respected principal, Dr. Dev sir, coordinator, Dr. Shaista, Pandey sir, all faculty members at Navjeevan College of Law, dear students and aspirants of IPS. Actually, today's lecture has its own different story to tell you. Because even though I have been honored by the Shaista ma'am in a very uh, kind word, Urdu words, so that kind of hat of Nawab has been put on my head. But I am telling you that IPR is not a figure of piece on my hat. But being a teacher of 25 different subjects of law, I can take the opportunity to roll on the few IPR issues like trademark. Now, I remember one of my students from Law of Injunction asked me that, sir, how this trademark is related with the law of injunction. Another young girl who came up differently and an entirely different question, saying that, sir, if I would be a successful lawyer, can I trademark my name for those services which I'm going to offer to the society? Now, one boy having a long beard asked me, sir, what exactly the resemblance of mark and trademark? And these were kind of questions in a very academic way, which I tried to answer. This question, even though seems to be very innocent, but it actually caused a kind of bombarding on my innocent mind. But another incident happened with me when one of my so-called innocent son of 5 years asked me a very simple question after watching the movie of Tarzan, that Papa, why Ajay Devgan have been killed by all four rowdies? What exactly his fault is? Now, at that time, I became very much serious about the subject of IPR. And then I realized the importance and significance of all the things which are there in the spirit of IPR. Now, moving toward these questions, and if I club all the questions together, I hope that I will take next one of your hour to discuss all the queries one after another. I would like to start with the very basic inquiries that if I ask you what exactly trademarks stand for, or what exactly it would contribute for the trader, because nowadays almost all things are moving around the trade, and trade and economics become the backbone for the nation. So everything what could be there in the sphere of your trade, that must have to be reflected somewhere. And therefore, the question what trademark is become very much relevant. So one can say that it is one of the type of intellectual property which would be there like any other form of IPR. But when it comes to the core component of the trademark, one can say that it is a sign or a combination of sign which is capable of being distinguish the goods or services from that of other. Now, if I want to make a distinction in between the goods, how I can make it? I can surely go for the sign, I can surely go for the words, I can surely go for any other design of that particular product. So one thing is very much clear pertaining to trademark that it's nothing but a sign or combination of that sign which actually distinguish the goods or services of one undertaking to another undertaking. Now, when it comes to the international development of the trademark, because even though the trademark is there and protected under the IPR regime, but we can see the significance of the trademark since the inception of the civilization, even though at that time it was not as such protected. We can see few kings who having certain kind of sign or mark on their sword. So this subject has entirely been recognized by the international community from Madrid to the TRIPS agreement. But out of that, Paris Convention played very much and very significant role in order to protect the trademark at international level. So it includes service mark, trademark, geographical indications. And I would like to stress upon Article 10 of Paris Convention, which stated and requires the member of that particular convention to provide effective protection against unfair competition. Now, again, one thing is very much clear. When we want to protect our mark as a trademark, it is giving the protection to the manufacturer of the company or to the service provider, reflecting that he is whatever he is doing is fair and there is no chance of unfair competitions. As Saistamam stated, people are not able to recognize what exactly parlay and partage stand for. And therefore, in order to stop that unfair competitions, we have to somewhere akin to the rules of trademark. Now, Madrid system also introduced to the world community date back in the year of 1891, and TRIPS agreement, which is also there as a standmark for the protection of a trademark. But how this trademark comes under the purview of Indian legal system? I remember that we have just adopted the system from Great Britain. So in British, we adopted that British trademark law, which was there in the year of 1938, and we came up first time with the Act of Trademark 1940. But later on, this trademark and change into Trademark and Merchandises Mark Act 1958, and further on the recommendation of Rajagopalachari, Justice Rajagopalachari Iyengar, who submitted his recommendation to the government of India, and on the basis of that recommendation, Trademark Act 1999 has been passed, which has been effected from the year of 2003 with trademark rules of 2002. Now, what major change has been introduced by this act? First and foremost, it actually increases the period of registration and renewal. One thing I would like to tell you in the context of trademark, that trademark is a kind of perpetual rights of the party unless he has not registered it, unless he has not renewed that trademark. So ultimately, he has to renew it within 10 years from the date of its registration. So the period has been extended from 7 to 10 years. It also simplifies the procedure for registration, and the scope of permitted users has also been increased. Further, it's providing the registration for the collective marks. Now, what exactly collective marks? I'll tell you. Then it provides an appellate board, which has been constituted under Section 83 of this particular act, and also make the trademark related offense as cognizable. Now, majorly, if you look toward the object of law, it actually protect the trademark and their infringement if in case some violation would be there. So ultimately, it provides a kind of channel. By that way, the remedy could be made available to the owner of that particular trademark. So referring to Lakshmikant Patel versus Chetan Baisha, in this particular judgment, court observed that we require the trademark law with two basic reasons. Firstly, honest and fair play, which ought to be the basic policy for the businesses. And secondly, when someone adopt or intend to adopt the business or services belonging to someone, then when it will result into confusion, in that case, it will divert it from the object of that trademark act. So ultimately, there must not be kind of confusion. There must not be uh, kind of deceitful use of that particular trademark by someone else. So ultimately, we want to protect the trademark, and similarly, we want to protect fair activities in the context of business. Now, it's a very simple activity for you. Can anybody tell me what this mark stand for? I'm just going to show you some marks which could be there under the regime of a businesses. Can anybody tell me what this mark stand for?
So it's a Nike brand of sportswear.
Okay. What does stand for?
Vehicle logo, sir.
It- It's a BMW. BMW generally use on the cars. It's a very reputed brand. Now, can anybody tell me what it stand for?
Android.
Android. Okay, great. Now this one.
What side is right?
Oh, great. This one.
Apple.
Apple.
Yes.
Puma.
Puma.
And
And
Google
now,
Puma.
now, what exactly these marks are doing? What exactly the role they are playing? I
Giving
just want to make it interactive instead of going one way.
So
I know
it
that,
is
yeah,
brand
yeah. What exactly it stand for?
brand making.
It's brand making. Okay. Can you please mute yourself?
Yeah,
Um, yeah. So ultimately, if I ask you what exactly trademark actually do, so first and foremost, it will help you to identify the product, right? So as you said, it's a BMW. It's a very reputed brand. Otherwise, secondly, it guaranteed its establishment. Now, if I'm saying LG, you will surely recall that LG is a very much uh, dominant market product, which is there in the sphere of electronics. And similarly, you can somewhere find out the origin of that particular goods as well. It is a means of advertisement. Now, if I'm saying kurkure, teda hai par mera hai. Now, you will surely figure out that Juhi Chawla is coming with the wrapper with a word saying tera hai par mera hai. So it's a means of advertisement. Further, it also increases the image of product into the mind of public. Now, I would like to take the example of Parle. Parle is a very known product in the context of biscuits. So ultimately, in order to identify the product and its origin, trademark help us. In order to establish a quality which has been guaranteed by the product, we can surely recognize. So surely, if I offer you the chocolate of Dairy Milk, and if I offer you a normal or local chocolates, obviously you are looking for most guaranteed brand. As I said, it would also help you to advertise the product. So I'm not talking about the kurkure especially. There could be other brands as well, which can be produced for or by way of advertisement. And similarly, it create a kind of impact on the mind of society. So therefore, we have to somewhere recognize the significance of the trademark. Merely saying that be vocal for the local would not make any sense at all. You have to somewhere make your product from a grassroots level to the top. And therefore, I would like to move toward the another query asked by my student, that what exactly resemblance of mark with a trademark. Now, if you could minutely observe to section 2 clause 1, 1 subclause which basically talking about the marks. So if I could take you back to one slide, you will find that there are multiple brands, there are multiple marks, might be in the context of BMW, in the context of any logo which could be used on the car, it could be on the Puma or any Gmail kind of thing. So by that way, you will surely recognize for what this product stands for. But I am very much sure that you will come to know about what exactly trademark is after going through the definition of it. Now, what the definition of this trademark is saying, that trademark means a mark capable of being represented graphically and which is capable of distinguish the goods or services of one person from those of other. So now the meaning is same except that represented graphically. Now what do you mean by represented graphically? Now if I could say you that there is a girl having a piece of butter in her hand, you will surely realize that she might be the girl of if I say you that there is a boy having the in his hand with the bucket of paint, you will surely realize that he could be advertising the product of Asian Paint. Let's have a look. So this is a graphical representation. Now the question is, can I go for registration of the domain name? Or can I go for registration of the smell? Can I go for the registration of the test? Can I go for the registration of any 3D picture? Now, these are kind of gray area that is there in the spirit of trademark. I'll come to that later on, but how the look on the definition once again. What it exactly trying to cover? I'm repeating, trademark means a mark. Now, mark would be in any form. So if I'm saying test, test could be observed in any of the form as a mark, which can be capable of represented graphically. So what is graphical representation? I told you, which is capable of distinguish the goods or services of one person from those of other, the third component, and may include the shape of goods, their packaging, and combination of color. Now, what is that shape of the goods? Now, if I ask you to have the Muti sandal in your hand and the Lux sandal in your hand, you will surely find out the difference. Moti always fine and round, and Lux have some different shape. So, by looking toward the shape of goods, also the buyer can identify the goods at the same way, packaging and combination of the colors. So as far as combination of color, it would also known as a trace mark for the product. So I'll come to it later on what it exactly stands for. So broadly, if you say a trademark could be in the word, as I said, teda hai par mera hai. It could be in the form of symbol. It could be in the form of phrase. It could be in the form of logo. It could be in the form of design. But the syndrome of that marks would not stop over here. So if you could minutely observe toward the definition of section 2 clause 1 clause which is there for the mark, it will include the brand. Now brand is nothing but the identification given to the product. For example, Raymond is a very popular brand nowadays. BMW is a very popular brand, right? Apple is a very popular brand. Now later is also one of the way by which we can identify the product, like in case of ELG, in case of SBI, in case of LIC, right? So later are like as I said, SBI or ELG. So by looking toward the later, we can identify the goods. As many one of you may observe that on the cars of Hyundai, they used to have the H, and on the cars of Maruti, they used to have the S. So looking toward that graphical indication of that later, we can surely identify the company, or quality or origin of that goods. Thirdly, label and ticket. Now, what is label and ticket stand for? So if I want to purchase the pantaloon shirts, what I'll do, I'll go and check the label on that particular goods. It may be in the context of any other brand. So labeling and ticketing is also one of the way which can be qualified for the registration of the trademark. Further, symbol and logos. Now, what are the symbols and logos? Now, as I said, LIC has another symbol of joint hand, right? So generally, in the context of services, these logos and symbols are being used. So it may be commercial services, educational services, or any other kinds of services. So as in case of Symbiosis also, we do have a separate band for this. So logos and symbols are being registered for the services. One important thing in the context of logos and symbols is that the same could also be registered under the Copyright Act of 1957. Further, numerals. Now, what is that numeral stand for? Numerals are nothing but the numerical numbers which would be there on the goods. Now, if I'm saying 500 pata ka chai, you will recognize that product. If I'm saying 555 cigarette, you will recognize that product. If I'm saying 303 capsules, you will recognize that product. So numerical could also be stand to register as a trademark. Further, shape of the goods. Shape of the goods, as I told you in the context of Moti and the context of Lux, but similar, it could be applicable to other product. So if I'm saying, as far as the designing of any particular product is concerned, obviously we can go for that. So if you could look to the Coca-Cola bottle, this has been registered as a trademark in Japan. And further, packaging. So packaging also, I told you how to pack the goods. So packaging also one of the, so if you could look into the choco biscuits, you will find a different packaging style. Like we do have in Hyderabad also, they have a different packaging style for the sweet. Now, title. Now, how title could be stand for registration at a trademark? So if you would look into the magazine or periodical like India Today, they could be registered as a trademark. Now, even though we are saying that these are the kinds of marks which can stand for the registration of the trademark, but what exactly attributes required for registration of these goods? Now, first and foremost attribute for the trademark is that it should be easy to pronounce and easy to write. It should be easy to pronounce and easy to write. Secondly, the device should be capable of being described by single word. Now, what does device stand for? The definition of device you can find in the Trademark Act. So those marks which mentioned earlier in the form of word, symbol, logo, if the goods is not falling in any one of the category, in that case, we can call it as a device. So device should be capable of being described by single word. Thirdly, it should be of such a character which spell correctly and written legibly. It should be such a character which spell it correctly and written legibly. And it should be short and attractive. So these are kind of attributes which are so required for the purpose of registration of the trademark. Now looking toward the characteristic, first and foremost, it represents the trade name. Now, how it can represent the trade name? If I'm saying Kirloskar, it's a very popular trade name in Maharashtra. If I'm saying Bajaj, it's a very popular trade name like Reliance. So it may be registered or unregistered. Now, what is that? If the product is properly registered, you will be similarly entitled to get all the rights which are confirmed by the Trademark Act. But it does not mean that unregistered product could not claim any right. Obviously, there are certain kinds of remedy that are mentioned under the Trademark Act for those unregistered products as well. Thirdly, it allows the buyer to know the origin and quality. As I said, that what exactly trademark do? It helps the people to identify the origin and quality of their goods. Fourthly, it's a perpetual in nature. So as I said, that it's a very distinct feature of the trademark which make it distinctive from the any other form of IPR. Because in case of patent, as in case of copyright, they can be used for the limited period. But here, perpetuity can be claimed by way of renewal of the registration. And distinctiveness. Now, how to define the distinctiveness is also one of the way which we have to somewhere akin with. So, distinctiveness plays a significant role as a character of the trademark. Now, moving toward the basic feature, as in case of Kirloskar Diesel Recon versus Kirloskar Proprietary Limited, it has been stated that trademark includes within it a trade name. In case of KM Osman versus Kam Sahib, in that particular case, it has been stated that trademark generally transmitted in connection with the goodwill of the business. So we are not supposed to disconnect our goodwill from the trademark. So if you want to transfer or assign or you the trademark on a license, in that case, the nature of business and the goodwill of that business must not be disturbed. So this is also one of the important basic features of the trademark. In case of London Rubber Company Limited versus Durex product, in this particular case, it has been stated that trademark is the property entitled to the protection of law and trademark has many species. Now, what does many species stand for? Because anyhow, we are known and aware about the different forms of marks which could be stand for registration of a trademark. Now, what is the spaces and different spaces stand for? Let me take you to this round. What are the spaces of trademark? Now, if I'm saying ISI, can anybody tell me what ISI stand for and what exactly the nature of ISI is? You can just text into the chat box. By that way, one-way communication could not be there. So one is service mark. So service marks would be there on the services provided by the manufacturer, and the definition of service is mentioned under section 2, which is just similar definition that is there under the Consumer Protection Act. So service mark is also one of the species which is introduced by the Trademark Act. Collective mark. Now, generally what happens when it comes to the registration of the trademark, it could be registered by individual name. But when it comes to collective mark, it could be registered by different entities with the same trademark. So it completely depends on the parties and the consent. Well-known trademark. Now, what is well-known trademark is? Now, well-known trademark means the very popular brand which is there, and someone want to take it as it is. So I would like to refer the Enfield company's case, where the Enfield diesel engine has been introduced in the year of 1978, and claim that this diesel engine could also be called as an Enfield bullet diesel engine. But the original proprietor of Enfield India objected on it and said that bullet and Enfield bullet is a very popular product and well-known trademark. Therefore, if someone is taking it, there is a chance to have take the disadvantage of the well-known and established product, and therefore it could not be granted. So, well-known mark is also one of the important mark which has been recognized by the Trademark Act 1999. Now, certification mark. Now, when it comes to certification, certain certifying authorities issuing certificate on or to the products, like in case of ISI, which actually giving the certificates to the LPG gases and any other kind of infrastructure or kind of goods which could be used as utensils for the kitchen. So these are the certifying authority who are certifying the product. As in case of hallmarks, they are giving the hallmarks to the jewelries. As in case of egg mark, they are giving to the foods. So certifying authority actually certifying the product that it is comfortable to use that particular goods. Now, internet domain. Now here, the question which have been put forward by my student, can internet domain name could also be registered under the trademark? The answer is obviously yes. At least the right of that particular domain name's owner could be protected. So I remember the case of that Akash Arora versus Yahoo, who started the domain name by the name of Yahoo India, and the original proprietor of that has objected the use, saying that these are deceptively similar and this name cannot be used. So therefore, court objected and court passed order in favor of the original owner, stating that internet domain name are also protected under the uh, Trademark Act 1999. Now, when it comes to the spectrum of distinctiveness, now it's a very important part I just want to discuss over here because without discussing this part, it would not be possible to go ahead as the title of this lecture itself stand for that spectrum of distinctiveness. Now, I remember the judgment given by the A and F company versus H and W company. In this particular case, certain spectrum of distinctiveness has been identified by Judge Hand, who stated that invented trademarks are always allowed. Generic trademark could not be allowed. Generic, the word generic is actually, we have to take it in a very common way and in a very common sense that where people are using this trademark with a very general connotations. For example, I want to register my trademark by name of water or by name of milk or by name of automobile or by name of watch or by name of car. These are very generic term where there is no chance to have the different meaning of it. So in that case, generic uh, kind of words, generic kinds of trademark could not be possible to register. But further moving toward a descriptive actually stand for convey on the immediate idea of identity, quality of that particular goods. So whenever it comes to the descriptiveness, it also eligible, which basically it is not eligible to register as a trademark, but when it comes to the second meaning of that particular word, in that case, it could be used. So when it conveys the direct meaning, having a chance to have the different meaning of it, in that case, we can go for descriptive um, trademarks as well. Further, suggestive trademark. Now, what is suggestive trademark? Suggestive trademarks are suggesting the name and the quality of the goods. So, suggestive is a kind of imagination that we have to somewhere apply, a kind of thought or perception we have to somewhere identify, which help the buyer to reach toward the conclusion about the nature of that goods. So, it could be in the form of earbuds. So if we are using the earbuds for the aeroplane or liquid antifreeze, uh, by looking toward the name itself, we can somewhere identify that it could not be freeze. So this could also be inherently stand for registration of the trademark. Now, moving further, arbitrary. Now, arbitrary means completely and entirely coming with a different notion of the idea. So, as in case of Apple generally we are taking in the context of food, but when that particular mark is coming in the context of different industry, different class, in that context, this product would also stand as a qualified for the purpose of registration of the trademark. And further, invented. Now, invented uh, is always allowed to register because, as in case of Kodak is a name given to the camera. It's an invented word, like anything available into the sphere of trademark. Now, when it comes to distinctiveness of that particular trademark, WN Sharp Limited versus Solomon Rose Limited, a court held that the word goods, base, superfine could not be capable of adoption in case of trademark. Further, in case of Godfrey Phillips India Limited versus Greener Food Beverages, in this particular case, it has been stated that descriptive trademark may be entitled to protection if it assumes a secondary meaning. So, whenever it comes to the descriptiveness, when it suggests the meaning, but having the chance to have the different meaning or secondary meaning, in that case, it could stand qualified for the protection of for the registration of the trademark and protection thereof. Thirdly, Lal Babu Priyanshi versus Amrit Pal Singh. Now here Clinic wanted to register the name and the shop by the name of Ramayana, and court observed that Ramayana is the name which has already been registered by more than 20 different trade owners. So ultimately, court stated that all those religious names which are general in connotation could not be used for the trademark. And lastly, empirical tobacco versus registered trademark. In this particular case, it has been scroll on and roll on the distinctiveness of that particular trademark. So here, court stated that distinctiveness we have to understood as some quality in trademark which earmark or make it designate the goods as a distinct from another. So whenever it, it is a chance to have the invention, that invented is always allowed, generic is not allowed, descriptive in some context could be capable to be registered, suggestive are always welcome, arbitrary are always welcome, fanciful are always welcome. But in almost all cases, we have to somewhere maintain that distinctiveness. Now, the question is how to go for registration. If you could look into the provision of the original Act of 1958, this register had two different parts, A and B. Now, all the trademark and all things are registered together, and the main office is situated at Bombay. So, Controller General of Patent, Design and Trademark is the person who is authorized to get registered the product, to whom we have to apply. Now, looking toward the Office of Controller General of Patent, Design and Trademark, you can find that this trademark registry is not only situated in Mumbai, but also in Delhi, Calcutta, Chennai, and in other places. So you can find the office of registrar over there. And if you find that any mark which is so qualified for the purpose of registration of the trademark, you can surely take that mark for the registration of the trademark by your own name, for the purpose of your trade. Now, when it comes to classification of goods and services, on principle basis, these goods are classified in 45 different categories. Out of that, 34 are given to the goods and 8 categories are given to the services. So, as in case of services, as I said, it will come um, banking services, then educational services, or any other construction services, electrical supply services. So, all services will comes under the category of service. So, in that context, the list is obviously inclusive, and the authority has to decide under which category the product will fall into. As in case of 34 categories, these 34 categories stand for different classes of goods, right? Now, um, I'm just moving toward another query that what if my trademark is being breached or violated by someone? What are the remedy available to me? So in that context, we have to somewhere ensure that whether there is actually the infringement of that trademark or not. Because being a practitioner, it's a responsibility of the lawyer to somewhere check and make the balance, and thereafter you can go for the claim. So first and foremost, you have to ensure that the person is not authorized use of the trademark. So against whom you want to claim, he is not the person who is so authorized to use the trademark. So you have to somewhere check whether it has been licensed to him or whether there is a kind of assignment being given to him. Secondly, the infringement mark must be either similar or identical or deceptively similar to the already registered trademark. So whenever you are finding that confusion or you are finding the deceptively similar mark, in that case, you have to find that you have to somewhere ensure that you can surely go for the claim. Thirdly, the infringing trademark must be used in course of regular trade in which registered proprietor or user is already engaged. So in that context also, as I said, those trademark which are not registered, they can also go for the pass on remedy. And and similarly, they can make their claim more strong. Further, mere oral use of trademark is not infringement. So suppose someone is saying that this is the iPhone, so it will not stand any kind of infringement. So we have to somewhere ensure that it must be used in the form of other mark only, and use of either whole or an adopted one by making a few addition or alteration. So if my trademark is being used by someone by way of adding something into that or altering something into that, in that case also it could make your claim some sense. Then what could be exception or defenses for it? Now, honest and confident owner. of that trademark is always protected. So he can surely go for the defense. Consent of original owner or proprietor expressly or impliedly given by him to that person. If he has consented, original proprietor is consented either expressly or impliedly, in that context also he can take the defense. Further, registered trademark is of some conditions. So whenever the mark trademark has been given, a certificate has been given to you regarding that trademark, had certain conditions involved into that. So in that context also, we have to somewhere ensure that these conditions were mentioned. So if the register office is saying that you have to use this trademark into this particular region, so obviously the another person from other region can use it, not expressly, but he can take it as a defense, saying that it is not applicable into that particular territory. And further, registered trademark is used by a person who has acquired it through assignment or any license. So whenever a person having the license or assignment, in that case, it could be a solid defense for it. And as I said, area of operation, it is also in that context, you have to keep in your mind that who are exactly your consumer. So this phenomena will also play significant role in that context. Now, what are the actions that could amount infringement? Now, Section 29 of that Act specify that what exactly it would amount as an infringement to the trademark. So, whenever you are finding any identical or confusingly similar trademark, in that case, it would amount as a violation or infringement of the trademark. Secondly, when infringing trademark is identical or deceptively similar to the goods and services in respect of which trademark is registered. Now we have to somewhere find out a difference in between confusion and deceptively similar. So whenever you want to deceive someone, you have some intention to deceive. So obviously you are aware that there is a kind of trademark which is there, but still I'm using it. So you are deceptively using it or deceitfully using it. But when it causing the confusion, like in case of Parle-G or Pate-G, so it is up to some extent we can say, not exactly, but up to some extent we can say it would be allowed because the geographical area, on the basis of that geographical area, we can surely distinguish in between them. But anyhow, if in one region two similar or confusing similarities are there in the context of both different trademark, in that particular context, it would obviously amount as an infringement of the trademark. Then infringing trademark is likely to cause confusion or a part on the part of public. So this is also a kind of infringement that could be there. And infringing trademark takes unfair advantage or is detrimental to the reputation. So whenever you are advertising your product, but similarly misadvertising someone's other product, in that case, it would amount as a violation or infringement of the trademark. So, what could be the remedies? I'm just moving and wrapping up my session. What are the remedies for the infringement? So, you have to institute a suit in a district court because looking toward the language of section 134 and 135, no suit shall be instituted in the court as in case of infringement of the trademark um, lower than the court of district court. So obviously you have to follow that course of action, and for that purpose you can surely go for temporary, permanent, or interim injunctions. But when it comes to confiscation of any goods, or you want to inquire whether there is a violation of that trademark or not, obviously court can pass an order relating to that, and obviously court will appoint a kind of commission under section 75 of civil procedure code, and the inspection of that could be possible. So commission could be engaged by the court by way of ante order. Now, under section 134, the same language you could see over here, suit for infringement etc to be instituted before district court. So if you look into the language, the jurisdiction of that particular court, we have to somewhere mind. So in whose jurisdiction actually the trademark been violated or infringed, or where the person defendant actually resides or work for again or doing business. At that place, we have to institute a suit. Now, under section 135, there are also other remedy pertaining to discovery of the document, preserving of the infringing goods, documents, or other evidences which are related to subject matter of the suit. So, restraining order could also be passed to the defendant when there is a chance to have the selling of the property, or when he is trying to get rid out of the execution of the decree. So, in that case, obviously, the party who is realizing that danger can surely go to the court to have some restraining order against him. Now, in addition to that, there are also other criminal remedies available. So, criminal prosecution can also be obtained by following two different procedures. So, either you can go to register a complaint to the magistrate, or you can go to the police officer to register your case. So, you can file FIR or you can go for the complaint. So, similarly, power has been given to the magistrate to issue the direction to the police officer to inspect and to inquire about the infringement of that particular trademarks. So, Section 156, Clause 3 of CRPC, which actually authorized the magistrate to engage the police officers in the inquiries of in the investigation of this particular violation of trademark. Further complaint before the police officer, in that context, we have to keep in our mind that whenever you are going for filing the complaint, it must not be registered to the person below the rank of DSP or ACP. These are two officials who are actually assigned for that purpose, and DSP or ACP, as the case may be, with consultation of the registrar of trademark, can go ahead and move ahead for the investigation of that particular matter. So, following sections can be invoked as a remedy, which is purely in criminal nature. Penalty under section 103 of trademark. So here you can see a punishment when it comes to the violation or falsifying any trademark. In that case, there is a punishment of not less than 6 months, but which may be extended to 3 years, or a fine not less than 50,000, but which may extend to 2 lakh. Similarly, in case of section 104 also, where a person who helped the accused to selling, to hiding, or provide any kind of services in that context, this should also amount as an offense. So, lesser punishment against is 6 months, and a punishment which could be extended up to 6 years. Fine not less than 50,000, but which may be extended up to 2,000. Penalty under section 105. If a person commits any one of the offense provided under section 103 or 104, he shall be punishable for the second or for every subsequent breach with imprisonment, which shall not be less than 1 year, but which may be extended to 3 years, and fine, which not less than 1 lakh, but which may be extended to 2 lakh rupees. There are certain administrative remedies as well, where a person can obviously go to the registrar to uh, cancel the certificate of registration, filing opposition within 4 months from the date of publication. One can also apply for the rectification of register by applying for removal of deceptively similar trademark. So, all remedies, as in case of civil remedies, injunctions order could be there. As in case of criminal remedies, all sections whatsoever mentioned under chapter 12 of the Trademark Act 1999 would be there, and some additional administrative remedies could also be there. Now, moving toward another important part, hope I'm finishing this in the next 15 minutes. Section 27, which basically talking about the Trademark Act 1999. So, what Section 27 is saying, that no action for infringement of unregistered trademark. Now, please don't take it literally. It has some hidden meaning as well, because if you look into clause 2, all things will be clear. So, I'm just moving toward clause 2. It stated, nothing in this act shall be deemed to affect the right of action against any person for passing of goods or services as the goods of another when when the goods are not so registered for the trademark. So, what exactly passing of remedies stand for? Because section 27 somewhere assuring about the passing of. So, in that case, if you are claiming the remedy of passing off, you have to prove something like that your mark has been used by misrepresenter. This mark is used in order to get some benefit out of it. And thirdly, there is some damage or violation of your rights. So ultimately, when you are going for claiming passing of remedy, you have to prove three essential in court of law. So misrepresentation of your mark, goodwill owned by the trader, and thirdly, damage to the goodwill. Now, further, question may be there as to what exactly the difference in between infringement of trademark and passing off. So in that context, Cadbury India Limited versus Neeraj Food Products, it actually make a distinction in between. So as far as passing off remedy is concerned, it is common law remedy. So those trademarks which are not so registered but very popular or well known, in that case, a person whose mark is being violated or infringed, he can go for pass on remedy. Further, as in case of trademark, which is actually the violation of uh, your registered trademark. So the law actually providing the remedy for it. So it would stand for statutory remedy. So passing up is a common law remedy. Started otherwise your trademark is a statutory remedy. Further, the use of defendant of a trademark of a plaintiff is prerequisite, whereas it is not so essential in case of passing off. So merely having the representation of that also would stand to claim it. And thirdly, in respect of trademark, registered trademark, it is only required to prove that infringement of the same or deceptively similarity um, is there in the context of breach of trademark, but it would not be sufficient to prove in case of passing of order. You have to prove all three contents in court of law as far as the passing of orders are concerned. Moving toward the geographical indication, I'm not going to cover entirely. I'm just going to cover the surface in order to identify exactly what difference is there in case of geographical indication and trademark. But in this context, we have to keep in our mind that geographical indication is nothing but the trademark to the place. So suppose we are saying the basmati is particularly applicable to that region. So it would be a kind of uh, class trademark for those who are working, who are running their trade into their that particular area. So all trader can use the name for the same area as basmati. So basmati and the what we can say the trader who are actually doing the trade uh, can prevent third person by saying not to use it. So I will not go in much detail, but surely go for the registration and process of registration of the GI. There are 10 important steps into it. We have to file the application. Then there would be preliminary scrutiny and examination by the register office. It will show cause notice if there is um, find something, can say misrepresentation or something like that, and publication in a geographical indication journal. Now, in the context of trademark and in the context of geographical indication, in both, you will find that on the very first day of the month and on 15th of every month, the registrar used to issue the journal, which you can find on their official website. Opposition to registration in that context, the register office will call opposition. There is a provision for renewal. Additional protection to notified good would also be there, and there is a provision for appeal as in case of registration of the trademark. So what exactly the difference between trademark and GI? Trademark can be used by a single owner of that trade. However, multiple users could use GI. As in case of use of name and address of the trader is concerned, there could be only one address, as in case of business of that trade in case of trademark. However, in case of GI, it will be applicable to all the regions. So, as in case of Nagpur, Nagpur is very popular for the orange, but orange is not actually coming from the Nagpur. It is coming from the nearby districts affixed to the Nagpur. So trademark can claim its color feature. So as I said, there are a number of forms which could be there in the context of trademark, but geographical indication does not claim any such kind of thing. While Deceptive graphical indication can be incorporated into trademark, which could be continued as a trademark deceptive, but the reverse of the same is not possible. So this was all about the um, trademark and GI. Now I'm just moving toward the concluding part of it. Here, party must have to follow the limitations. So whenever you are finding that there is infringement of your rights, you have to file a suit within 3 years if you want to claim the remedy by way of injunction or by way of passing of order. Further, you if you have a justified delay and if you are properly justifying the delay to the court, in that case, court will not deny the order of injunction to it. So obviously, if court consider that delay as genuine one, so in that case, obviously court will favor you and court will allow you to go forward. Modern trademarks are also similarly entitled to get protection. Now, in that context, I told you smell mark, taste mark, and yeah, so these all are comes under the purview of Trademark Act 1999. This trademark registration is applicable to both goods and services. So 36 goods and 8 different services. Classification of goods and services are based on international standard. So if you could look into the nice classification, you will find all the classes of goods one after another. And distinctiveness is the major qualification of any mark to be qualified for the trademark. So you have to find out that distinctiveness on the basis of the genericity of that good, deceptiveness, suggestiveness, arbitrary, fancifulness, and all the other things. And GI is nothing but a trademark for the particular region or the area as a trademark. So this was all about the lecture. So ultimately, at the end, if you could look and observe the points, we tried to cover all the points one after another. What exactly trademark is? What are the international development about a trademark? How evolution will happen in the context of India pertaining to trademark? What exactly trademark do? Marks and trademark. What are the similarities and this definition of trademark? For what qualifies the mark to be registered as a trademark, then what are the characteristics of trademark, mark associated with the trademark, spectrum of distinctiveness, procedure of registration, remedies, enforcement of the trademark, GI and trademark, and thereafter conclusion. So this was all about the trademark, and I hope I satisfy the mandate given by Dr. Shaista. I would like to stop over here, um, and I would be open for the question if any you have. Over to you, Shaista ma'am.
Yes, sir. Thank you so much. Today we have seen trademark and geographical indications. We have seen the characteristics. We have seen registration. We have seen infringement, remedies for the said infringement of trademark and passing off. Even we have seen process of registration of geographical indications as well. So the floor is open for the questions. There is one question in the chat box, sir.
Yeah. Oh, I have to see the chat box. Let me go to that.
Yes. In the chat box, it has been mentioned that by Yogesh Patil,
Yes, sir.
if any person has registered a brand in India and same brand name in any other country, then what will be the remedy if any controversy arises?
Now, in that context, first and foremost, we have to understand that trademark having the geographical limitations. So, if you register trademark in India, it will be applicable in India only, right? But on the basis of origin, if your registered trademark is um, earlier registered as compared to other brand, in that case, you can take conventional benefit within 6 months from the date of registration. So if you're registering trademark today and someone is registering trademark within 3 years in another country, and you are realizing that there is a violation or infringement of your trademark, in that case, you could surely go with the Paris Convention. So conventional protection you can surely claim. But here you have to keep in your mind that it has geographical boundaries. So in that context, first answer would be it will be limited to India, but conventional benefit you can surely get it within 6 months from the date of it.
Good afternoon. This is Manish Joshi from Navjeevan Law College. I'm a final year student.
Yes.
Sir, first of all, I really thank you for this is really a excellent session by you. I want to ask you, what are the challenges related to trademark in India?
Now, pertaining to challenges, because see, you can see the manifestation of the law. Because even though you are giving the power to one authority to decide something, as it similarly happened in the context of sensitizing something like in case of censor board, if you could compare both the authorities,
Okay.
right? So there is always a manifestation of using the law. But yes, as in case of yes, as in case of non-conventional trademark, like in case of taste, like in case of sound mark. So in that case, it is very hard to maintain. So if I am saying you uh, very non-conventional trademark, so it is very hard to compare this trademark with any other registered trademark. So non-conventional trademarks are kind of gray area, which is I found very challenging nowadays in India.
Yes. Any other questions? It seems everybody's happy, sir. So we proceed towards.
I really appreciate for your share whatever you said at the beginning. Let me have some reply to that share, and by that way, I'll just end up my session if you don't mind, sir. So,
Yes.
फूलों का व्यापार करो या खुशबू का कारोबार, फूलों का व्यापार करो या खुशबू का कारोबार, हमारा ट्रेडमार्क अलग है, हमारा ट्रेडमार्क अलग है, चाहे इस्तेकबाल करो 100 बार. So with this, I'll take your permission to leave. Thank you so much for giving me the opportunity. I'm indeed thankful to Professor Dr. Rao, Professor Shahista, for inviting me as a guest lecturer. Thank you so much. And Yogesh,
Thank you, sir. So I take the opportunity to thank the resource person for today's program, Dr. Pankaj Umbarkar, sir. I thank Honorable Bade Sir, Bade Ma'am, our Principal Sir, my co-coordinator, Pandey Sir, and all the participants present here. Yesterday, we have seen the session on patents. Today, we have covered trademarks, and tomorrow, stay tuned for copyright. Let us on, all of you, your video so that we can have a virtual photograph together. Can we stop screen sharing, sir, so that we can have photographs?
okay.
Kindly on your videos, please, so that we can have a virtual photograph for today's session. Thank you all. A great pleasure for today, and thank you, and see you all tomorrow for copyright session. Thank you. Thank you, sir.
Thank you, ma'am.